Today on Plainsight Spotlight, the New York Times Company versus Microsoft Corporation et al., case number 123CV11195 in the Southern District of New York. The newspaper of record, the New York Times, has sued OpenAI and its investor that doesn't really want to be called that for regulatory purposes, Microsoft Corporation, in federal court for copyright infringement by ChatGPT, OpenAI's much-hyped artificial intelligence chatbot. The Times alleges that ChatGPT was trained on copyrighted news articles, essentially the entire newspaper going back decades, and that OpenAI and Microsoft didn't pay for their use of them. Quality journalism costs money to produce, and while this is just the latest battle between old media and the tech sector, it is an interesting one because the case could turn out to set an important precedent for how copyright law applies to large language models, or LLMs. The issues are fairly complicated, and there are so many of them it might end up being too much for one judge to make sense of. So no matter what happens, there's a good chance this case will go to appeal. Whichever judge the case is assigned to will look at the copyright claims based on the test the United States Court of Appeals for the Second Circuit has set out for copyright infringement, because the Southern District of New York is part of the Second Circuit, one of 11 geographic circuits that group judicial districts throughout the country. The Second Circuit test first examines whether the plaintiff owns a valid copyright in the material being sued over and whether the defendant had access to the work, and then whether the original work and the derivative work are, quote, substantially similar. According to DLA Piper, one of the largest law firms in the world, which here is just citing a Second Circuit copyright decision over alleged copying by Michael Crichton in his book Jurassic Park, quote, courts in the Second Circuit analyze substantial similarity by first filtering out similarities that result from unprotectable aspects of the original work, such as facts, public domain material, and stock plot elements, and second, examining the total concept and feel, theme, characters, plot, sequence, pace, and setting of the similarities that remain to determine whether similarities rise to the level of substantial. There isn't much of a question that the New York Times owns copyrights on its work. The newspaper has submitted a spreadsheet listing them all, tens of thousands of pages long, as part of its complaint. There also isn't much of a question that ChatGPT, verbatim repeating New York Times articles, is substantially similar to the original. We can expect a lot of fighting over which specific act constitutes copying in this case. Just because ChatGPT reads an article, does that mean it copied it? What if no one ever asks ChatGPT about the article? The examples the New York Times provides of verbatim copying all require prompting of ChatGPT first with the article itself, which is a bit different than displaying a piece of art in an art gallery or publishing a plagiarized paper. But it's not clear if it's different enough to get OpenAI and Microsoft out of trouble with the law. It's possible one or both sides will ask the court to rewrite the entire test for copyright infringement because it's just not up to date enough to encompass the complexities of LLMs. Not everyone thinks the lawsuit is that big of a threat to OpenAI. Tech critic Mike Masnick suggests that the New York Times itself is notorious for copying the work of other journalists without attribution, and he's right. But generally, the Times does not do so verbatim for paragraphs on end. Masnick says that the Times is effectively arguing that summarization of text amounts to copyright infringement, but most of the complaint focuses on verbatim copying, and if a summary requires verbatim copying to create, then there may still be a problem. Then there's the issue of fair use. OpenAI is likely to argue that ChatGPT's ingestion of thousands of articles constitutes fair use under the law, so there should be no finding of infringement. But given that OpenAI is selling access to ChatGPT, making it a commercial endeavor, that argument might be a tough sell, especially as more users think of ChatGPT as a search engine where they can get their news without buying a newspaper subscription. Also, copying the entirety of the newspaper won't help OpenAI much in this regard. To view these documents for yourself and learn more about OpenAI's litigation history and corporate structure, you can view the OpenAI profile page on Plainsight. You'll find the links in the description below.